how do you secure or capture your trademark rights? Generally, there's two ways. You can either use it in commerce and simply enforce your rights through state actions in whatever area where you are using that mark to represent your product or service. So that's a limited use under common law. But the only thing you have to do to secure your trademark rights is to use that trademark to represent your product or service within that area. Now, the other way is to file your trademark with the U.S. Patent and Trademark Office. Now, in order to do that, the trademark has to meet certain elements. It has to be distinctive. And the U.S. Patent and Trademark Office looks at trademarks to try to find distinctiveness. Now, the scale goes like this. It goes fanciful, arbitrary, suggestive, descriptive, and then generic marks. Now, a fanciful mark has really no outside meaning. It is thought of just for this purpose, and it's unique. Say Kodak or Xerox, they have no meaning outside of using that to describe the product or service. Arbitrary could be something like the Apple for Apple Corporation, right? It describes a type of product, but it's used arbitrarily to represent the company. So in that way, it has a secondary meaning and it is distinctive for that company. A suggestive mark would be something more like Microsoft or something like that, where part of the name indicates what it is or has some indication of what it's representing. So it in some way begins to describe the business, but not exactly. It just is suggestive of what it is. Now, again, that has secondary meaning. It is distinctive from a generic meaning of the word. Again, it's protectable at some level. And then there's descriptive terms. Now, descriptive terms, they have to be so used and associated with a product that these descriptive words take on secondary meaning. That is, people disassociate the description from generally describing the good to, okay, this word or this trademark symbol represents just this good. So through use, it can achieve secondary meaning and then it's protectable. And then there's generic. And a generic term is just that. It loses its distinctiveness or never gains distinctiveness. It abandons its secondary meaning. And if this happens, it's not protectable. So in some cases, a word that is protected, a fanciful word, for example, could become generic through overuse. If it achieves that level of generic use, then in that case, it loses its protection as a trademark. Okay?